Okay, good afternoon. This is Curt
and Brad Pinsky.
All right, and we are here for another edition of Fire Law Roundup. Hopefully, boy,
we're good. We're recording.
Is it recording?
It is.
Okay, wow. There's something crazy going on my computer, but at any rate, it's August 14th of 2023. We have a crazy week.
This is great. And so hang on till the end because we're leaving the best for the last, so to speak.
The best of the worst.
Yeah. Well, let's start off in New Haven. And we always kind of joke that, I don't know who gets sued more, LA or New Haven, but and I'm not trying to be mean here, but I've always kind of thought this is a silly lawsuit a little bit. And I don't mean to be pejorative, but here we have an assistant chief who alleged that the city, the fire chief, several others were interfering in basically his employment contract, such that he then retired. And the court has thrown this out in favor of the defendants, including Frank Ricci. For everybody who knows him, he's the one who took New Haven to the U.S. Supreme Court and was victorious there. So here, basically, there are a number of claims that the assistant chief makes. And again, I'm not trying to be mean by any imagination, but the court even here kind of says these are kind of thin. First he's like, well, there's negligent supervision, right? And that the employees and everyone were negligently supervised. And
well, he felt the chief should have intervened. I think that's what it is. He felt the chief should have intervened.
And the court there, with regard to that claim, says, look, they said that's a discretionary act, how they acted. It's not ministerial, meaning they acted for policies, and is fairly universal. I'm going to say for every state, almost every state, we have the same principle, which is that employees of a public entity are not going to be liable for their discretionary decisions following a discretionary practice, right? Not policy, practice. But they would be liable if they failed to follow a non-discretionary policy, and policies are non-discretionary by their terms. So here he says there's no evidence of that they failed to follow a policy, and if it was they failed to act properly in their discretion, which supervision of an employee, of course, is in most instances
it's inevitably discretionary. Yeah.
Well, maybe not with things like sexual harassment type thing to say, well, you can't harass somebody. There's no right, but generally how you oversee them is discretionary. And the court also said, listen, there wasn't an actual loss. Your retirement was voluntary. It's funny because I have this exact case right now that we're working on to submit, or just submitted actually to court. But where an employee resigns and, is voluntary, it's all voluntary, they kind of waive their rights to protest anything. And the court says that's what happened here. He voluntarily retired. So there can't be a tortious interference with my contract claim, right? You interfered with my employment. Well, but you retired. Had he been forced out, that might have been something different. If there was coercion or duress where he had to retire, that would have been something different. And then I've never seen this before. He makes a claim for invasion of privacy, but couches it as, well, you interfered with my seclusion or solitude, which the court says, okay, that's invasion of privacy. I've never heard of that. That doesn't mean anything.
No, it is. It's one of, I think there's 4 or 5 different branches of the tort of invasion of privacy, and intrusion upon the seclusion is one of them.
Wow.
Yeah.
And the court makes short work of that and says, well, there's, factually, there was a recording of a phone conversation. The plaintiff tried to say, well, it was an intentional kind of breach of my privacy, but the court said, I guess I listened to it, and it was, you just didn't hang up when you left a voicemail, and the voicemail kept recording because you didn't hang up the phone, so there wasn't any intentional invasion of privacy. I thought that, and I can't imagine that one phone call would result in that, but in any event, it was strange to me that the attorney would plead that knowing you just didn't hang up the phone. It's crazy.
I don't know if because it seemed to me that perhaps they didn't know how she ended up with the recording, but somehow she ended up with the recording, and I'm assuming shared it with the chief or whomever, And the whole thing, the whole thing to me comes down to big city union politics, and I think Frank Ritchie, I'm glad, I know Frank well, and I am glad that I was not the fire chief where Frank Ritchie was the union president. Okay, you know what I'm saying? Because he is going to challenge you and challenge you and challenge you, and that's basically, and I mean that in a complimentary way. But that sometimes is going to be very painful. And I think what the chief, the assistant chief was saying was that, Frank was coming at him almost with the cooperation of others, which, I can understand how he could perceive it that way, and I'm telling you, it's so difficult to be a big city chief these days, fighting the union, fighting the politics, fighting the people. And many chiefs really feel like they're on an island by themselves. And it's really, if you have anybody to lean on, it's got to be the other people in the front office. And when you don't have them to lean on, it can be a very difficult challenge.
Yeah, I'll tell you, as a chief who had, a union, although 12 people plus part-timers, not hundreds, right? But I took a different view, and then we'll move on, but I took a different view of the union. I said, listen, that was a contract that was negotiated between the municipality, my boss at the time, right, and the union, and it's my job to adhere to that. And if I overstep or misstep, then the union should take me to task on it. They fought hard for that. And it is more typically the union who says, oh, you're misapplying or misinterpreting. And I get it. I think if the union sees that the employer is not living up to their side of the contract, they should be fighting it. They fought for that.
Well, they did, but I'm going to tell you, I would say for my 29 years in Providence, we had labor management warfare, open warfare from when we started, because the city was trying to close companies, and they were successful ultimately in doing some of that. They were cutting benefits. They were doing things that if I had the time to go through it, you would agree the city was unethical. Okay, now I want you to think about you in your situation as the fire chief, where the city has behaved unethically, but yet you have to keep running the fire department.
Yeah.
Okay.
Yeah.
And they've, and I think that's the challenge, is how I've said this in many of my classes, but how as a leader do you lead people who believe they've been cheated? And it's a challenge. And I don't think, I don't know the politics in Manlius, but I'm going to tell you, it gets very, very nasty. And you have elected officials who are looking, the mayor, and they want to become the governor or a congressman or whatever. And they're doing things knowing they're not going to be there when the proverbial shit hits the fan. They're going to be someplace else. They make a decision to fight something, and then they walk away, they go get another job. And the firefighters are still there, and they're fighting all of these. I've seen pensions cut, healthcare cut, salaries cut or not honored. We had not to get off the subject. We had a
we're so far off the subject.
Well, I know. We had a mayor. I want you to just understand just how unscrupulous some of these are. We had a mayor, and this was to the chiefs, called the chiefs in about a week before Christmas. City Hall is all decorated and everything. And he says, you guys haven't had a raise in 8 years, and I understand that you're part of management, so we're going to give you a 16% raise. We're going to bring you up to where the raises that the police, because the union and the city were at war, so we didn't get any pay raises because the firefighters didn't. Bottom line is, they call us in, 16% rate. We all left there like on cloud nine, left City Hall. Right after Christmas, the chief calls us and he goes, the mayor misspoke. There will be no raises.
Misspoke? Jesus.
Yeah, misspoke. That's the kind of crap.
And and the chief has to bear that.
He does.
I will tell you, I'll tell you, in a smaller department, that's harder, because in a big department, the chief is not sending the guys into the fire, or maybe not going in with them. In a smaller department,
That's
you
right.
piss off your guys in the afternoon or in the morning, but in the afternoon, you're working a structure fire with them.
Right.
Bitter
Yeah.
feelings, they stay on the fire ground despite.
I hear you.
Okay. Anyway, well then why don't we just stay in Rhode Island since we've been talking about Providence? This is really interesting. And it's interesting because I wish in New York we could do this. So what happened is, and I totally agree, a Rhode Island fire district, correct me if I'm wrong, a Rhode Island fire district had a casino submit a $50 million plan, and the fire department is going to review it, as they should, right? Because look, we've got so many issues with a casino. If there's a hotel, parking garages, look, fire protection's a big deal. And so they're reviewing the plans. The fire district charged them $203,000. That's the part I love, because I don't know how much it really costs, but in any event, they charged $203,000 to review the plan. I wish we could do that here in New York, and we should be able to. The casino argued a couple of things. One, they said, listen, you can't charge us at all. And if you can charge us, you have to stick to the town's valuation and how the town charges, because you're acting under a town ordinance when you're doing this. And the court basically answered very much in the favor of the fire district. One, you absolutely have the authority to review the plans. And two, you are not bound by the town's method of charging. And so your $200,000 bill, have at it. And I thought that was great. I don't know where that comes from in the law in Rhode Island, but that's awesome.
Well, the ability to charge is part of the fire code. Okay, so it's built into the state fire code, and jurisdiction is given to the state fire board of appeal and review. So it's a public body, quasi judicial, I guess. They sit and primarily will hear requests for variances, but they also are statutorily authorized to interpret the fire code. So the courts have to give deference to the way that the fire code is interpreted by the board. And one of the issues here was that the fire code authorizes the state fire marshal to charge for plan review, but it doesn't specifically say anyone other than the state fire marshal. But all of the fire marshals for each of the municipalities are all assistant deputy fire marshals. So there was an interpretation about whether or not the assistant deputy fire marshal for a particular fire district was the state fire marshal. Because again, the way the statute reads, it says the state fire marshal shall. And the Board of Appeal and Review said, yes, that is, okay? And also Lime Rock charged their amount based on the schedule that the state fire marshal charges. And what the allegation was, because of some of the wording in the state fire code, it suggests that it's pursuant to municipal ordinance. So the question was, the town of Lincoln had a municipal ordinance for the plan review of the building inspector. Are they limited to that particular ordinance? Because a fire district doesn't have the authority to issue ordinances. And the state Board of Appeal and Review interpreted that to say, no, whatever regulations that the local fire district creates would be considered an ordinance for the purpose of that. So now the casino didn't particularly care for that decision, so they challenged it. They they didn't even appeal it, which I thought was unusual. They filed a request for a declaratory judgment. And the court first determined that it did, in fact, have jurisdiction, which, again, you would think they would appeal the decision as opposed to, but at any rate, they sought a declaratory judgment. And the Superior Court said, no, I mean, the State Board of Appeal and Review is entitled to deference on the interpretation of the fire code. And that's sort of number one. And statutorily and otherwise, we agree with that ruling. So. Now, who knows? Who knows what our state Supreme Court is going to do if and when the case ends up getting to them. So, right. But it's a pretty big deal for the folks in Rhode Island. Outside of Rhode Island, it's really not. Yeah.
Well, and if it's overturned, right? If they lost on appeal, here would be the hard part, because now presumably all these districts are going to start charging the fair value of their reviews. And if that's overturned, that they can't, wow.
Yeah, hopefully the Supreme Court, if it gets there, is going to do the right thing for fire departments anyway. Because you can say, oh, $203,000 is an enormous amount, and it no doubt is, but that may require them hiring someone to go in there and do a lot of the inspections and code enforcement stuff. And they may actually have to retain like an engineer, because, you start thinking about casinos. Casinos aren't compartmentized. You think about the casino near your house, up where we do your conferences, Turning Stone, and you have that just wide open atrium where all the machines are and everything. Plus you've got theaters and bars and restaurants.
Parking garages where there's going to be electric vehicles, and people are like, Appendix D, I think, to the Fire and Life Safety Code is turnarounds for aerials and vehicles. So you're measuring parking, right, turnarounds and where spaces are. It is an intense process. I say that only because I participated in the evaluation of a turnaround, and it took us a full day just to look at one turnaround as we're moving the aerial around. And I mean, it was insane what the engineers go through. So it is a ton of work. I totally get it. Ton of work. Okay, let's go to the Ninth Circuit. Here we're going to go to Stockton, City of Stockton. Now, there's a reason I'm doing it in this order. For those who read your blog and then follow us here, I'm going to do this case, and then I'm going to go to the Mobile, Alabama firefighter, because I read a part of the decision, which I'll go through the facts in the Ninth Circuit, I read as governing the process of the suit we're going to discuss in Mobile, Alabama. So, Ninth Circuit, we have a court who upheld the firing of the fire chief. This, you want to see how long court cases last. This is back in 2011, right? So anyone who thinks being part of a lawsuit is no big deal, live with this for 12 years, right? It is. In any event, the court held, and this is important, that the fire chief was fired for legitimate, non-discriminatory reasons, and that's kind of part one. And the court held that the chief who was fired was unable to show that these were pretextual reasons. Remember that when we get to the next case, everybody watching, because that's where I'm seeing the next case is going to go. So we've discussed a million times the McDonnell-Douglas test, which is burden shifting, but ultimately, and they go through it here, right? You have to show, the plaintiff has to show they're a member of a protected class, that they were qualified for their position, that they experienced an adverse employment action, right? So all three of those are pretty easy. And as you always say, it's the fourth prong, that's the focus, where we have to, where the employees got to show, the plaintiffs got to show that other people in a non-protected class or outside their protected class, for example, protected class female, non-protected class male, they have to show that those people were treated more favorably, or that other circumstances surrounding the adverse employment action kind of gave rise to an inference of discrimination. And we'll talk about those here. So on the alternative, a plaintiff can simply show or merely show that they're through either direct evidence, meaning an actual fact I can prove, or circumstantial evidence of discrimination. So here we've got the chief who says that I'm part of a Christian coalition. Now, this is very interesting, right? So I'm not really sure that Christianity is exactly a protected class. I was a little more surprised.
Well, when you make a decision, an employment decision based upon religion,
correct.
You're not, it's not that you're a protected class, but you are the victim of a decision that was based on religion. So.
Now, it's kind of funny, and I'm off topic for a moment, to show that, well, people outside my protected class. Well, when your protected class is the dominant majority, who are we pointing to? Muslims, Jews, it's not, you got to show they're treated differently or better. I always laugh. I'm like, okay, well, if you treat Christians like hell, we can treat Jews and Muslims like hell too. It doesn't matter. I don't know. Can I say hell on YouTube? Who knows? So, but here there were comments of opinions about the chief who's a member of a Christian group. And they said these mere comments, the court said, that doesn't constitute a discriminative animosity, that simply because there was comments by people that he's part of a Christian mission and that this mission is a church clique did not rise to the level of discrimination needed to prove it. I'm not suggesting that people should then go out and make comments of a derogatory nature about people's religion or the groups they belong to, right? For example, one might believe, and you could say, oh, Muslims are all terrorists. Oh, I'm not making a comment about you. I'm just talking about Muslims in general, right? That is not how you should read this decision. It's just that these pejorative negative phrases wasn't instructive or wasn't evidence of the person making their statement's own bias. And that was the key. He wasn't saying, I think the Christian clique is bad. He's just making a general reference about other person's perceptions. And that's key here. If the fire chief gets up and says, oh, all Christians are crazy, or all Muslims are terrorists, or all Jews are greedy, whatever you want to say, that's different because he's reflecting their own bias. And then the decisions you make pursuant to your bias are going to be tainted. That's not what the court found happened here. The court found here that they're talking about this person making comment was talking about other people's biases. Which, I hate to think of this and I hate to say it this way, but Trump was just, as much as people like or hate him, probably the latter, Trump was just talking about Governor Christie. And as he's in the audience, he turned to someone, he said, oh, don't say he's a fat, overweight, whatever. That you shouldn't say that he's fat and overweight. That's mean. I would never say he's fat and overweight. You're saying he's fat and overweight. You shouldn't say that. I would never say that, right? So that's not what we're talking about here, but that's what it brought to mind that anyway.
Well,
so
I think the issue, the fundamental issue here is that the chief was doing taking some religious liberties while he was supposed to be working. All right. He brought some religion into the workplace. He went on a religious leadership, went to a religious leadership conference on taxpayer time, and I'm not sure at taxpayer expense, but certainly on taxpayer time. And there were some allegations that he was playing favorites based on religion. So I think it's really hard to tease out religion from the decision making here. And I think that the court spent a lot of time talking about that, but that the religious decision making, like, for example, if he had gone to a different denominational conference, it still would have been the same issue. It wasn't because he went to a Christian event. It was the fact that he went to a religious of any denomination event at taxpayer expense that didn't really have a benefit to the taxpayers. And some of the other decisions as well.
Yeah, and the court makes, and this is because it's going to be my transition now over to Mobile. The court makes point to say they couldn't prove that the reason they actually fired him was a pretext for the real reason, which was their discriminatory animosity, hatred, whatever. Pretext matters. And so now I want to jump into, because you and I have covered this, I swear, at least twice in the past.
We did. We covered it once when she was terminated. Now we've got a female firefighter from Mobile. Number one, she was terminated. Number two, we covered it when it was only about 3 weeks ago when two African-American captains were disciplined, and now they're suing. One was terminated, one was suspended. They're suing to overturn their discipline.
So here's the basic facts, because I got to tell you, on paper, she's got a really good case. So what basically happened, to go through it again, is she's a probationary firefighter with very good reviews from at least the captain. She, when she joins, there's no prohibition against tattoos. She has a tattoo on her neck. They implement a non-tattoo policy, and in order to, which really shouldn't affect her at all, but you can't do something ex post facto after the fact. So, but regardless, she says, okay, I'm going to grow my hair out so it can't be seen. 3 weeks ago, we dealt with the chief or a chief comes down and starts interviewing her and demanding to inspect her, which I thought was a possible Fourth Amendment search and seizure issue. In any event, people came to her rescue saying, what are you doing? Start making phone calls saying, was this authorized? Because the individual, the probationary firefighter at the time, was actually trying to grow her hair out and did actually make other attempts to cover the tattoo. Now, and this is where timing matters, because timing means a lot, right? She ultimately is terminated. Right, jumping forward, she's ultimately terminated, and we don't, unless I'm wrong, we don't know why she's terminated other than conduct unbecoming. We don't know what that conduct was at this point, but she's claiming, listen, I am a African-American, I believe, homosexual female. Well, that puts her in at least three, right? If she's Jewish or Muslim, we're doing good, right?
And she's Muslim. And she's Muslim.
That's so she right. That's so we've got four classes. So the McDonnell-Douglas test that she's right, that she's hitting it out of the park just by her mere existence, and she's got great reviews by at least the captain who came. I think the same captain who came to her defense, but her captain, right, her direct supervisor is giving her good reviews. So now she's terminated. I mean, the timing, right? So on October 6th of 22, she files a formal grievance alleging discrimination on the basis of sex. Now, why does she do this? Because there's numerous comments made by at least one individual that says, I don't think women should be in the fire service. She complains about those comments. She alleges that people are aware in the higher ranks of those comments. So she has made her case on a first blush, right? The problem is now, a month and 4 days later, after which her tattoo is no longer visible, hair only grows so quickly, she's terminated, right? A month after this formal grievance, she's terminated for conduct unbecoming. That is why I started with the prior case about pretext. They are going to have to find, despite her great reviews, despite her compliance with a policy that didn't exist at the time she was hired, and despite all of her complaints about discrimination on the basis only of sex, by the way, although I thought there was a religious portion here. In any event, their employer's got to come forward and say, we have a totally independent reason.
Right.
That is going to be very tough.
If they can, then they can. But if they're going to try to say, here's the thing where they get in trouble, all our employees are at will, so we can fire them anytime for any reason or no reason, right? Well, you can't get by the McDonnell-Douglas test if you think you can just fire everybody because they're at will. You have to be able to show that you had a reasonable basis for doing that.
And by the way, that basis for doing it is 100% not a motivating factor, right? That the religion, that the sex had no basis whatsoever. It was not a, as we would call it, but for reason, right? But for her being a, well, even so, if she was female, if she was gay, if she was Muslim, if she was black, none of those had any way related. And by the way, throw in, and it doesn't matter that she filed a grievance about any of this against us. None of that was related to the fact that she did something else. And look, unless, and this happens, the lawyer may not be saying, oh, by the way, she also skipped work. By the way, and I'm making this up. By the way, she also told her supervisor to F off. By the way, all these things, right? There's going to have to be something the employer is going to come forward with. And this, again, is why employee evaluations help or hurt you. You and I have done cases where they really help, where you have a bad probationary employee and they're constantly writing you up saying, on this day, you didn't do this, you didn't do that. Unless those exist, which the employees not in, normally the employees would acknowledge bad performance reviews saying they were a pretext, they were a setup.
Brad, I don't know if you saw this part of it, but it's an allegation from the earlier case filed by the captains. The captain was ordered to change her evaluation to downgrade her and recommend termination, and he refused to do it. And that was, I'm assuming, behind one of the reasons why he ended up getting terminated.
Yeah.
or the other one ended up getting disciplined. They were, so again, change the facts, or again, we don't know what the facts are, but assuming that he, let's assume that he, for personal reasons, graded her higher than she deserved.
Okay.
Okay. If you assume that, if that is the issue, and I have no way of knowing that, but that now you've got another issue. I mean, how do you authorize somebody to do an evaluation and then you want to second guess their evaluation? That's
right.
That's a problem in and of itself. So
this is headed for settlement as far as I'm concerned, but for the fact it's gotten to the point of such high publicity, if by nothing else, you and I. But this case leans in her favor. If you had to score this,
to agree. I'd be a little concerned. Now, again, maybe the fire department has some other facts that we're not aware of, but what's publicly available, it certainly, certainly is tipping in her favor, I would say, and also the captains.
And, we have seen a case, Scott, a long time ago where the employee became so bitter. I cannot think what this was. The employee became so bitter and dissatisfied at work. They were constantly complaining. And I think the employer says, oh, they're a horrible person, bad employee, they're bitter. And yet the defense is, but you made me that way. You keep treating me this way. How do you expect me to react? Who knows? Maybe they come forward and say, oh, you were so pissed off and upset all the time, and you weren't getting along with your employees and your coworkers, and you're creating a disharmonious atmosphere and environment that we got rid of you. Who knows what comes forward on this?
This kind of gets into an area that I've been lecturing on and studying in, but personality disorders and different things. But very often, someone's sized up as being a problem employee, and then the department gets in a situation where saying this person's just going to be a headache, just going to be a headache, just going to be a headache, and now they have this bias, and whether it's racially motivated or gender or orientation, whatever, or they just legitimately feel that this person's a problem, then they're looking for an excuse or a way to get rid of them, and they rationalize that kind of process as okay because they've reached the conclusion that the person's no good. And you see that a lot. And I'm not saying that's what's going on here, but I see it a lot. And I think it explains a lot of the things that we see. So who knows what's actually going on here?
Well, let's go to the last one, which is who knows what is actually going on. And if you have been waiting for this is just it's a head scratcher. So start off with this, because you and I had covered the other side of this story.
This is a case out of Rochester, New York, and let's say it started last August with an African American firefighter. What's his first name? Jared Jones. Okay. And he claims that he was ordered to go to a racist house party by his white captain, Jones.
While in an engine, and he's not the driver, and he's not the officer.
While on duty. Now, let me give you a little bit from my experience. This kind of stuff happens all the time. I'm not going to a racist party. I don't mean that, but if there's a party in the district, and you're out on the air or whatever, that that certainly is not unheard of in any fire department I've ever been on. So, but it happens. But he claims that he was wrongfully ordered to go there, and then there were all these racist. I don't even know how you'd say it, because there was no overt things, but there were things that he characterized as racist. He characterized it as a spoof of Juneteenth.
Juneteenth, even though this is held, I think, July 7th. It's right. They're saying well after Juneteenth, but he said, and this gets relevant, that there's a bucket of fried chicken and watermelon right. And that there's somebody hanging in efficacy, right? They one of the politicians, but again, and I'll let you continue. I want to focus on the fact he's in the back of the engine. He's not driving. He's not the officer. He is brought there to this place.
I would restate it. his company went there, and he's
Yep.
part of the company, so he went there as part with the company. I mean, it wasn't, the chief, the captain didn't come down and say, I'm ordering you to get on the truck and we're, oh, come on, guys, we're going whatever, But at any rate, he characterized it in a certain way. And if the way that he alleged it was actually what happened, then colorably there's a problem. There's it should not have happened. Okay, but now, of course, the whole thing kind of blew up. The captain ended up having to resign. He was going to be disciplined. And the department, pretty much said that it was inappropriate for them to have gone there and so on and so forth. Okay. Well, the second shoe in this case is now dropped, where the owner of the house, and his name is Dr. Nicholas Nicosia, I guess.
Yeah, he's a dentist.
A dentist, who's claiming that his business has been disrupted in a really fundamental way, that many of his long-term employees have quit, including a dentist, and several of the other people, that they've been subject to threats, that his business is off over 30%. He's been removed from several boards. His wife, I think if I recall,
he said he wasn't home, and his wife was the one throwing the party.
Well, let's go through all the harm. Right? I'm just going through all the harm that he has suffered. He and his family have suffered.
He's an outcast in society now.
And basically that he's been canceled. He's been canceled, and that that cancellation has occurred at the hands of Mr. Jones's attorney. And another elected official, who both of whom are white, by the way, who are, apparently notably progressive, and that are using this to further their own individual interests, whether it's be elected or, making a name for themselves. But you can read some of the quotes here, but apparently, and when I read it, it sounded to me like this was a block party, a big party, 30, 40, 50 people.
How they depicted it.
There were 10 people.
Yeah.
And it was a party not by the dentist, but by the dentist's wife. The dentist is a Democrat. His wife is a little more on the conservative side, apparently.
He says, I'm an independent. I vote on both sides of the issues.
And so there's factual questions here. It was a kind of a potluck party where people brought food. So, it wasn't that he brought Kentucky Fried Chicken. Somebody who came to the thing brought Kentucky Fried Chicken.
Allegedly, right?
Allegedly, right? And again, you can go through the facts here. But at any rate, the dentist has sued, and he's characterizing it. And I want to term it properly here. He's calling what's happened, and this now from the dentist perspective, he's saying that I am the victim of a quote hate crime hoax, unquote. And he goes further in his complaint and talks about and I'll read it to you. Hate crime hoaxes have been defined by the Black scholar, political scientist, and public intellectual Professor Wilfred Riley as a, quote, cottage industry, unquote, in which individuals, in this case exemplified by the dentists, are smeared as racist over invented stories of extreme discrimination. As described by Professor Riley, hate crime hoaxes may not constitute real actionable crimes, but often involve false allegations or elaborate hoaxes to make it seem as if racism or racist crimes occurred. And he's alleging that he's been, his life and his what he's worked for, and I guess he took over his dad's dental practice, that their dental practice has been permanently and irreparably damaged by the maliciously false allegations. And he didn't include Jones as a defendant. Okay, so one would think that maybe some of the allegations that Jones have made, got spun up and spooled up by the attorney and by the elected official, but pretty clearly accusing them of blatantly making false statements about what the nature of that party was about.
Yeah, incredible. It is so hard to know who's telling the truth here. That right?
Well, I think it's possible. It's totally possible for Jared Jones to have felt the way he felt and perceived it the way he perceived it.
Yes.
But for those perceptions not to be what other people would perceive. Okay. It's just like, we talked about this before. When you and I are sitting together at Fenway Park and we see a close play at second base, my friend, you and I are not going to see it the same way. It's, you're a Yankee fan. I'm a Red Sox fan. We're going to see it. Now, in sports, we have instant replay. But you take that away, my friend, and you're going to see, and you're going to say, no, he was out. And I'm going to say, no, he was safe, right? Yeah. So it's possible for different people to perceive things in a different way and interpret things and recall things in a different way. And that's totally understandable when you're dealing with the people who perceived it, okay, saw, heard, smelled, felt, and tasted something. The attorney did not see, her, hear, smell, taste, or, whatever. Neither did the elected official. They were spinning based on really on, what they were told. But, did they take it in a different direction? I mean, did Jared Jones call this a Juneteenth spoof? Or was that something that came afterwards? So I think that'll be one of the interesting issues to kind of tease out, what did Jared Jones say? And then did the attorney and the elected official accurately repeat it? Or was there a difference between what he said and what they said?
And the allegation, start with the attorney part, the allegation that the attorneys involved in this, that the lawsuit was a setup, right, was part of this hoax. If true, if the attorney knowingly verifies a complaint, right, or puts forth a complaint that he knows is perjurous, right, he's suborned perjury effectively, this guy's getting disbarred. There's a lot.
I honestly, I don't see that here. I really don't think that that Jared Jones.
But he's the defendant. Right? Isn't the attorney one of the defendants?
Right, but I hope that I don't want to believe Jared Jones would misstate what factually happened. But I think it is possible that it got spun up as part of the campaign. But who knows? I mean, you might be right. And you know what?
Well, I'm not saying I'm right or wrong.
It's possible that the attorney and the elected official are right, and Jared Jones are right, and the dentist is wrong. We don't know.
Right.
We don't know. So it's going to come down to who can prove what when they get to court.
And of course, don't forget the city of Rochester, I believe, already investigated, right, and already came down with some findings. Not that their findings, are way on this, but this is incredible.
From what I read about that investigation, it was really on the proprietary of the engine going over to the party in the first place, not so much what happened at the party.
Right. On the other hand, if you say, well, if I'm the engine, right, crew, the officer who gets reprimanded and says, well, wait a minute, I just thought we were invited for lunch and it was a free lunch. We're out on the road. We drove by to grab some fried chicken or whatever people brought. We were invited to 10 people. There's no alcohol. There's no hate behind this. You would think somebody would be raising that as a defense, and maybe they did. We didn't see that part of it. But again, wow, this is incredible on both sides. I have no idea the truth of what happened. I'm just saying, wow, on both sides.
Yeah. I mean, the whole week, all the cases this week just seem like they're, other than, the first couple really weren't that big, but the last couple here were just like diametrically different opinions about what actually happened.
And yet it all comes down to pretext. What was the pretext for the party? What's the pretext for the person with a tattoo getting fired a month after she files a complaint? What's the pretext for all of this? And it makes me want to suggest to everybody, don't do anything unless you announce your pretext and you can back it up. But wow. Okay, so I guess I'm going to end this week with my legal word, wow.
Yeah. It was, just an incredible collection of cases this week, and we'll see what next week holds. So,
every week, if we were getting paid for this, I'd say this is the stuff we get paid for. Unfortunately, we don't.
I guess, but trying to sort through it, I just hope that we get some sort of resolution on this fairly quickly, because this last one particularly here is just very, very concerning.
Oh, no way. The discovery in this is going to go into every attendee's participation in the Ku Klux Klan rally. They're going to look at pictures. I'm making this stuff up, by the way, but they're going to look at pictures of people's Facebook, the discovery and who these people are and were, and they're known racists or they're not, they're all Democrats or they're all Republicans. I mean, this is going to get crazy. And there's no settlement that's ever going to occur in this case, in my opinion. This is going to be defended right to a jury where the dentist has a burden of proof to prove this was a hoax. Wow.
Yeah. All right. Well, that's going to do it for another edition of Fire Law Roundup. We'll see you all next week. Brad, thank you very much.